Subheading D. To the extent they have not been waived, the claimed privileges are not jeopardized by the subpoena. Plaintiff's assertion that the subpoena seeks grand jury material and documents and communications protected by the attorney-client privilege and work product doctrine does not salvage his motion. As an initial matter, the subpoena does not, as plaintiff suggests, seek any material, documents, or communications. The subpoena only seeks Pomerantz's testimony. Although Bragg assumes that the questioning will stray into impermissible territory, the court declines Bragg's invitation to blindly speculate about what questions might hypothetically be posed to Pomerantz at the deposition. Bragg's throw everything at the wall approach to privilege is unpersuasive. As an initial matter, Bragg concedes that Jordan represents that he does not seek information protected by New York's grand jury secrecy laws. Although Bragg vaguely asserts that the committee's inquiry could still include questions about grand jury matters, this court will not quash a subpoena based solely on Bragg's seemingly endless stream of what-ifs. Even if grand jury secrecy were implicated by the subpoena, Bragg's argument makes little sense because Pomerantz was not involved in securing the grand jury indictment. Indeed, at the time Pomerantz left the District Attorney of New York, there had been no New York State criminal prosecution of Donald Trump. And even assuming Pomerantz did have some relevant information about the grand jury, Pomerantz is clearly aware that he cannot disclose details about grand jury proceedings, since he professes that he authored his book in such a way that his account of the investigation did not violate the grand jury secrecy requirement. With respect to Bragg's various other claims of privilege, the court is unpersuaded that judicial intervention is needed to ensure that any privilege that might exist is preserved. Pomerantz is impressively credentialed. He had a long and successful career. He graduated from the University of Michigan Law School, served as a law clerk for a distinguished federal judge, clerked at the United States Supreme Court, was a law professor, worked as a federal prosecutor for the United States Attorney's Office for the Southern District of New York, and as a criminal defense attorney for many years, including as a senior partner at a prominent New York City law firm, Paul Weiss, Rifkin, Garten, and Garrison. In short, Pomerantz is a very experienced, sophisticated, and extremely capable attorney. Moreover, the committee's procedural rules permit 2 additional lawyers to accompany Pomerantz to the deposition. This court is confident that Pomerantz and his counsel are fully knowledgeable about the privilege and confidentiality obligations he owes to the District Attorney of New York, and indeed are duty-bound to ensure that they are maintained. Footnote. Pomerantz has made it abundantly clear that he will seek to comply with Bragg's instructions and to invoke privilege. This claimed deference to the district attorney's command is a surprising about-face, particularly given that Pomerantz previously declined the district attorney's request to review his book manuscript before publication. Pomerantz is now represented by a team of capable lawyers from his former firm, Paul Weiss. Bragg provides no reason to assume those accomplished lawyers would not also be fully knowledgeable about Pomerantz's ethical obligations with respect to privilege and confidentiality. Accordingly, the deposition should proceed in the normal course, question by question, and Pomerantz is free to object personally or through his counsel and to decline to answer any questions when and if appropriate. Indeed, defendants confirm that to the extent that questions are asked that Pomerantz believes he is not permitted to answer, he would retain the ability to decline to answer or to assert an applicable privilege. Bragg expresses concern that the committee's rules permit a partisan decision maker to overrule privilege objections at the depositions and to order a witness to answer a question. The court cannot decide before the fact what information or answers Pomerantz may validly be required to give or the validity of any objections he might make. But in the event that this situation does arise, Pomerantz has avenues for judicial review. Pomerantz complains that he is in a legally untenable position because he will be forced to make a choice between legal or ethical consequences or potential criminal and disciplinary exposure. The court again is unable to surmise whether Pomerantz will actually face such a dilemma. In addition, the court notes that Pomerantz is in this situation because he decided to inject himself into the public debate by authoring a book that he has described as appropriate and in the public interest. Finally, Bragg cannot seriously claim that any information already published in Pomerantz's book and discussed on primetime television in front of millions of people is protected from disclosure as attorney work product or otherwise. On the record at the hearing on the motion for emergency relief, Bragg's counsel admitted that Pomerantz's book did not preserve the confidences of the district attorney's office. While Bragg maintains that Pomerantz's inappropriate disclosures waive District of New York privilege, that such a claim is belied by the District of New York's inaction in response to Pomerantz's known plan to publish a book about the District of New York's investigation into President Trump. If that information ever was protected from disclosure as attorney work product, that protection has been waived by the District of New York, by the District Attorney of New York. Bragg concedes that he was aware of Pomerantz's intention to publish the book before it was published. Although Bragg contends that he diligently sought to protect the privilege, he merely reminded Mr. Pomerantz of his obligations not to disclose privileged or confidential information and requested the opportunity for pre-publication review. By Bragg's own admission, Pomerantz declined the request for pre-publication review and proceeded to publish the book anyway. There is no evidence that the District Attorney of New York took any action before the book was published, such as seeking to enjoin publication or distribution. Similarly, after publication, the District of New York again took no action. It did not request a gag order, seek an injunction, pursue Pomerantz for money damages, refer Pomerantz for an ethics inquiry, or even raise any concerns about the publication with Pomerantz. This repeated inaction constitutes acquiescence to the disclosure of any otherwise privileged information. Because Bragg has never claimed that any information in the book was privileged, he may not do so now simply because it is convenient. In sum, the court is unwilling to hypothesize about and prophylactically rule on the permissibility of questions that may or may not arise at the deposition of Pomerantz. Bragg has not shown a likelihood of success on the merits. The court therefore need not address the other prongs of the temporary restraining order analysis. Conclusion. For the foregoing reason, the motion for a temporary restraining order enjoining the subpoena to depose Mr. Pomerantz and enjoining Mr. Pomerantz from appearing is denied. In our federalist system, elected state and federal actors sometimes engage in political dogfights. Bragg complains of political interference in the local District of New York case, but Bragg does not operate outside of the political arena. Bragg is presumptively acting in good faith. That said, he is an elected prosecutor in New York County with constituents, some of whom wish to see Bragg wield the force of law against the former president and a current candidate for the Republican presidential nomination. Jordan, in turn, has initiated a political response to what he and some of his constituents view as a manifest abuse of power and nakedly political prosecution, funded in part with federal money, that has the potential to interfere with the exercise of presidential duties and with an upcoming federal election. The court does not endorse either side's agenda. The sole question before the court at this time is whether Bragg has a legal basis to quash a congressional subpoena that was issued with a valid legislative purpose. He does not. The parties are encouraged to speak with one another to reach a mutually agreeable compromise regarding how the deposition of Mr. Pomerantz will proceed. The court will retain jurisdiction over this dispute and any ancillary claims arising out of the inquiry by the committee relating to the use of federal funds in a manner that may influence the 2024 presidential election. In other words, Bragg may not file successive proceedings under a different index number if and when the committee in fact issues another subpoena that he finds objectionable, or if there are issues with respect to the Pomerantz deposition. The parties are hereby ordered to file a joint status report within 30 days of the date of this order. So ordered. April 19, 2023, New York, New York. Mary K. Viscasil, United States District Judge. Thank you for joining me for this dramatic reading of the opinion and order. And good night.